Hi, my name is Ricardo, and in this video I would like to briefly talk about the Protection of Personal Information Act and fundraising for non-profit organizations. Now, the Act is relevant in many ways to non-profit organizations. In fact, it's applicable to non-profit organizations if they do process personal information. However, this video is going to focus on one particular aspect, and that is on fundraising. Now, it's worded differently within the context of the Act. It falls under the concept of direct marketing. Now, if we look at the Act and we look at the definition of the Act, it basically says that direct marketing is to approach a data subject either in person or by mail or electronic communication for the direct or indirect purpose of promoting or offering to supply in the ordinary course of business any goods or services to the data subject. Now, if we just stop there, some organizations do provide goods and services and may very well fit within that definition of direct marketing. But this is the area that I would like to focus on, the B part of the definition, which basically says requesting the data subject to make a donation of any kind for any reason. That is fundraising for non-profit organizations. So for purposes of the Act, we could say that fundraising for non-profit organizations constitutes direct marketing. Now, the data subjects have a right not to have their personal information processed for purposes of direct marketing by means of unsolicited electronic communication except as allowed in terms of Section 69. Now, you would notice that, there are a couple of concepts that we're not going to deal with in terms of this video. Concepts like a data subject, personal information, unsolicited electronic communication. Those concepts are important in terms of understanding the full scope of this particular application to direct marketing. But in this short video, we're not going to focus on that. I just want to pick up on a couple of issues. Firstly, the data subject may object at any time to the processing of personal information for the purposes of direct marketing. Now, we might say in this context for the purposes of fundraising, other than unsolicited electronic communications referred to in Section 69. Now, of course, this Section 69 is important in relation to non-profit organizations. And let's have a brief look at what Section 69 says. Now, Section 69 basically says that processing of personal information of data subjects for purposes of direct marketing through electronic communication is prohibited unless the data subject has given consent or is a customer of the NPO in this context. So two C's that we see there. First, consent or customer. Now, Section 69 provides that the NPO may approach a data subject for consent if that consent was not previously withheld. Secondly, only once and in the prescribed manner or form. So this kind of consent is very specific, and the organization has only got one opportunity of obtaining that consent. And the consent is specific in the sense that there's a specific form that must be used, and that form is referred to under the regulations as Form 4. That's an example of the first page of Form 4. Now, if consent has not been obtained by the organization, remember the other C. The other C refers to the data subject being the customer. So in that context, the data subject must be a customer of the NPO, and the details of the data subject must have been obtained in the context of a sale or the production of services, and that should have been obtained for direct marketing of the organization's own similar products or services. And the data subject must be free to object at the time of the collection of his or her or its personal information, or during each communication being sent out by the organization. So that communication being sent out to donors must contain details of the identity of the sender, being the organization, contact details to which the donor may request communication to cease. Now, I know it says data subject, but in this context, we refer to the donor. And so, in a nutshell, the Protection of Personal Information Act has effectively changed the game plan for non-profit organizations in relation to fundraising. Unless somebody is regarded as a customer, the organization must get consent, and that consent must be in the prescribed form and manner. Also, there's only one opportunity to get that consent, and the consent can be withdrawn. So in terms of fundraising, there's a new standard required on the part of non-profit organizations. Now, it's not complicated, so the organization can comply with those provisions, but the organization must be aware of the provisions of the Protection of Personal Information Act, and also understanding, those concepts that we spoke about. So I hope this video has been helpful. Thank you. If you do like it, please click the like button and share if you think others will benefit from this video. Thank you so much.